The Corporate Transparency Act goes into effect on January 1, 2024. On December 13th, 2023, FinCEN, the Financial Crimes Enforcement Network, had a webinar to go over a lot of the questions that people have. Well, not everybody could make it, but thankfully I was there and I've got some answers. Hi, I'm John Strohmeyer with Strohmeyer Law, where we help our clients leave no unfinished business. While I am a lawyer, I am not your lawyer, so don't take the advice from some talking head on the internet. Make sure you talk to your own advisor about your specific circumstances. Now, as I mentioned, there are a lot of questions about what's going to happen when the Corporate Transparency Act kicks in on January 1st, 2024. We've got those questions. We've been looking for answers. FinCEN has been good about updating their FAQ to give us more and more answers. The reality is they're not going to answer every question. There are going to be close cases, and in some cases, I expect that they're not going to give us direct answers because they don't want to box themselves in by saying, hey, this is the answer, and that then provides some hope or some opportunity for someone to plan around to get around the regulations and the reporting that's required by law. So let's go ahead and get into it. Here are the questions first that I thought these are good answers to finally get. Now, first, there is not an upper limit on the number of beneficial owners. This is one of the questions. It seems pretty obvious. The point of the reporting is to make sure, hey, if you've got a beneficial owner, if there's somebody who has control or can direct ownership of a particular entity, they should be listed. FinCEN was clear. There is not an upper limit to the number of beneficial owners. If somebody qualifies, either because they have substantial control over the entity or because they own 25% or more of the entity, then they need to be reported as a beneficial owner. Basically, if there were some limit, then it creates opportunities for people to get around the reporting that Congress wanted us to go through. On the other end of things, FinCEN did say there has to be at least one beneficial owner. You're really not going to get a situation where it's basically a ghost ship. There are no beneficial owners. There has to be somebody who is in control. Sure, you can set up an entity where there are no 25% or more owners or controllers of interest. You could have 100 people who each own 1% of the entity. Even in that situation, FinCEN made clear somebody's going to have substantial control. You're not going to have a ghost ship that's just going on its own through the seas with no direction and just somehow does things. Somebody has to be listed as having substantial control over at least every entity. I'm sure it's possible, but I can't really think why would there be an entity out there that nobody has any substantial control over. So again, this is something to think about. Yes, you may be able to find an entity that doesn't have any 25% or more owners. You're not going to have somebody, or you're very unlikely. How about that? Very unlikely to the point that FinCEN's going to be very confused that there are no beneficial owners. Another thing that was good to have confirmed, entities that have always been exempt are not going to be required to report that they are in fact exempt. Earlier, you've probably heard me say, well, look, if it's an exempt entity, spend the time, go ahead and report. Shouldn't take you more than 5 minutes to log on to FinCEN, type in your entity's name and taxpayer identification number, and just say, we're exempt and move on. Well, FinCEN has come out and confirmed in a few, not only on the webinar, but in their FAQs, that they do want to make it clear that if you're exempt and you've always been exempt, you don't need to claim that exemption. What does this really mean? Does always mean always? An example that's going to come up a lot, 501c organizations. Generally, you're going to form that entity as a limited liability company or a nonprofit corporation, depending on the state you're in, and then you'll go and apply for your exemption from the IRS. Well, that exemption is not going to come for another year or so. So during that time, your entity is not exempt as a 501c organization. And because it's not exempt as a 501c organization, it's also not exempt from reporting under the Corporate Transparency Act. So if you start a new nonprofit next year but don't get your exemption until 2025, guess what? You're going to have to report your beneficial owners from your filing time until you get that letter from the IRS. Then you'll have 30 days to log back on and claim your exemption. But going back to what they've confirmed, if it's always been exempt, you don't have to file and claim the exemption. I think the reasonable way to look at this is if you've been exempt from day one, meaning January 1, 2024, you don't need to go in and log on and claim the exemption. Go ahead and treat it as we've always been exempt during the effective date of these regulations. If you've always been exempt from the effective date on, there's nothing to do. So the existing nonprofits that would not have been exempt except they were formed years ago and got their exemption long before the CTA went into effect, don't worry about it. That's what I'm pretty sure they're telling us. As a lawyer, I know people are going to have a lot of fun. Lawyers are going to have a lot of fun arguing about, well, does always mean always, or did it really mean kind of always, or maybe sometimes always? Look, there's a kind of practical reality of if it's exempt as of January 1, it seems like that's the reasonable answer to go with. Another good thing that they confirmed, company applicant information will only need to be updated if it was wrong. If it changes later, because one of the company applicants moves, changes businesses, offices, that will not trigger a filing. Again, earlier on it seemed like, well, look, if the information changes, we need to update it. And that includes if the company applicant changes. This is why I was going to, one of the big reasons why I didn't want to just have my information reported, with directly. I was going to get a FinCEN ID and have any relevant entities use my FinCEN ID. That way, it's on me to update my direct information directly with FinCEN. Well, the good news is, as a company applicant, my information, as long as it's correctly reported, once I change or move anything, I won't have to update FinCEN. It's not going to trigger a bunch of filings. I think this is actually a good thing for everybody. Look, a lot of times clients will come form entities with us and then we won't hear from them again. This is a great way to make sure that, look, even if we drift apart for whatever reason, they don't have to worry about updating my information. Another good thing that they confirmed, the 90-day extension that applies to reporting companies formed or registered in 2024 applies only to the initial report. There was a change in the regulations towards the end of 2023 where for entities formed in 2024, there are going to be new companies. It's not going to be a 30-day timeline to get their initial report in. It's going to be a 90-day timeline. What they've confirmed, though, is that that 90-day timeline applies only to the initial report. So if you file an initial report, or if you form an entity on January 1, you'll have 90 days to get that entity's initial report in to FinCEN. But if something changes, then it's still only going to be the 30-day clock that you've got. So initial report, 90 days for entities formed in 2024, then 30 days to update with any changes, basically giving a larger lead time for that initial report. Once we get to 2025, it's 30 days for the initial report, 30 days for any changes that need to be updated. Finally, the last thing that was good to hear, they talked a little bit more about how the electronic reporting is going to go. There are going to be 3 different ways that you can electronically file your FinCEN beneficial owner reports. Way number 1, there's going to be a web form. You'll go log on to the website, you'll type in your information and click submit. It'll go right into FinCEN directly. Good news, it's a web form, you just type things in. The bad news, there's not going to be a way to save the form, so if you get distracted, something needs to change, computer goes out, basically everything that you've typed in will be lost. That gives us way number 2. There should be a PDF form coming out shortly. That PDF will allow you to type in the information, and then you'll upload the completed PDF along with the front and back images, or at least the scan of the photo ID that's going along to be required as part of your FinCEN BOI reporting. That gets uploaded to the FinCEN portal. Good news about this allows you to save that form on your desktop. You can create it, alter it, edit it. If something changes, you can make a change to that PDF. Finally, there are also third-party systems that will be there are third parties that will be allowed to use the API that FinCEN has to upload reports. And so they'll have their own backend. Now, if you use one of those reporting systems that already exists using that API, that'll be a great way for you to use those other tools. I'm sure those other tools, at least some of them, will have the ability to save, keep all the information in one place. Now, that was the good news. Here's kind of the not so awesome news. The questions that were asked but not really addressed. Now, first, no clarifications were provided regarding questions about trusts. I work in trusts and estates. I deal with these all the time, going through and looking at what needs to be reported, all the different situations that can arise. What if you have co-trustees? What happens then? Does the reporting do the reporting obligations get triggered for all of the grantors, beneficiaries, and trustees if only one of them gets triggered? It wasn't answered, and FinCEN promised that more guidance is coming, but here we are 2 weeks later, we still haven't gotten that guidance. So that's a little frustrating. Number two, we didn't get any specific recommendations on what to do with stubborn beneficial owners. So there's the fear among a lot of advisors that, well, some beneficial owners are going to be unwilling to report. What is the reporting company supposed to do? Well, FinCEN didn't provide any specific guidance, just said, hey, work with those people and get them to know that they have a legal obligation. I'm not disagreeing with that. The reality is you're going to have some people, there are going to be people who say, look, I'm just not gonna. That is where they start crossing into the willfully not complying with their known legal obligations. There's a difference between the willful test that's set out and, well, I just haven't heard about it. Obviously, this has been an issue of me talking about it. I've been talking about this for years to attorneys, CPAs, and other advisors. People saying, I've never heard about this before. There are going to be people who don't know about it. But this is talking about the beneficial owners who know and don't want to provide any information. FinCEN, I think, is worried about saying, well, if you can't get the information, then just write us a note and explain the situation. They don't want to get in that situation. They want to make it clear the reporting obligation was passed by Congress, signed into law. This is what needs to happen. They really don't want to give somebody an out to say, well, I don't want to, here we go. So it's going to be on the reporting companies to get that all put in there. Next, we didn't get any real clarity on the expired identification documents. Now, when asked whether the beneficial owner information would be updated if, say, a driver's license expired or something like that, they pointed us back to the FAQs, and specifically FAQ H.2. What are some likely triggers for needing to update beneficial ownership information? Well, it says any change to a beneficial owner's name, address, or unique identifying number previously provided will trigger this obligation. So if you get a new number, then that'll trigger it. What they didn't say was just because it expired, you don't have to do anything. So if you're looking to justify not filing a new report on the expiration, well, they had the chance in their FAQ to say, look, the expiration could have triggered this. We're not saying it. If you're looking to be a nervous Nelly, like risk-averse pessimist like me, then you might say, well, look, they just listed a number of these items, but didn't say everything. So because they didn't say everything, we're just going to do it if your ID gets updated anyway. Again, I would like a lot more clarification on this. They really didn't give us what we were looking for. So finally, getting to the questions that I asked that were not answered and not really even acknowledged. So I put in 3 questions, none of them got answered. So question 1, can you please provide an update on the status of the filing system? What stress testing is being done to ensure that it will work as planned on January 1, 2024? And, frankly, I shouldn't have even had to ask this question. They should have started their presentation with, hey, everyone, things are going great. We've been stress testing this. We've had a number of our partners with APIs dump all sorts of records in, and everything's going great. We're looking forward to everybody getting started January 1, 2024, because we know the first thing you want to do on a holiday is get in and start filing. Well, they didn't do that. What are you going to do? All right, my second question that was not addressed. Well, will an undivided community property interest in an ownership interest in a reporting company owned by a spouse of an identified beneficial owner cause that spouse, in addition to the identified beneficial owner, to be reported as a beneficial owner? Basically, if one spouse in a community property state owns 25% or more, does the other spouse whose name isn't down, do they get brought in as a beneficial owner? Should they be reported? Look, I'm married. I live in Texas. We have community property here. For my law firm, the interest is only in my name, but my wife has a 50% interest. She's just not on the records. Well, does this get listed? Yes or no? I mean, this is an interest, this is an issue that shows up for 13 states, a good chunk of the population. I feel like this is a reasonable bit of guidance we should be getting. Now, I'm going to go ahead and say, like, my position right now is look, my wife should be listed down as having exactly the same one half interest. Sure, she might end up in a divorce with all of it being on her side or all of it being on my side, dividing it in half and saying, well, look, John had 50% and then community property says it goes over there. I don't think that's going to be the way it works. Honestly, I think under both the ownership test uh, in the statute and in the regulations, I think we probably have to say, well, this is joint ownership. That is an undivided interest, so that we should be treated as both being beneficial owners of the property. Now, sure, I'm going to take the risk averse pessimist view on this. I'm looking to make this kind of easy for people to apply. We're probably going to want that to be the right answer. Now, for me to get convinced otherwise, you're going to have to find me a divorce or a family law attorney who says that somehow we're not in a relationship, that those community property rules don't apply to us. Yeah, I don't think that's going to happen. Finally, my last question that was not addressed, hopefully we'll get some updates on this. Will the ability to remove and replace a trustee of a trust that has an ownership interest in a reporting company result in the person who holds that power to remove and replace the trustee being treated as either having substantial control over the reporting company or being treated as owning that interest? Now, this is a tough question. There are a number of trust positions, specifically a trust protector, where people might have this ability to change trustees, change the trust agreement, change the beneficial interest. I think this is going to be something where we don't have a good, clear answer, but it would have been nice to get some more clarity on some trust questions. And this is one I still wrestle with. I honestly think when it comes down to close calls like this, you're going to have to read the trust agreement, see what those powers are, see what they actually empower that trust protector, is usually what the person has, or it may just be another person who can remove and replace a trustee. I think it's just going to have to come down to look at the trust agreement. You're going to have to make a judgment call. This is something to work with your advisors on. So there we are. A number of questions that have been answered, some that are still outstanding. We are in the last few days before this kicks in. We will have more content coming for you about the Corporate Transparency Act. Don't forget to look around. We will link to that other content. Thanks so much. We'll let you know what else comes about.